Thank you for joining me in our Strategies of Success WebEx series today. This WebEx is entitled HIPAA Omnibus Rule. Are you ready? My name is Carolyn Parker, and I'll be presenting the information on this topic today. Should you have any questions during the presentation, please feel free to submit them as you participate, and I'll answer them at the end of the presentation. The information provided in this training module is not intended to be legal or medical advice. It is recommended that participants not rely on this general guide in structuring or analyzing individual transactions, but that professional advice be sought in connection with any such transaction. Nothing herein is the official position of Allegiant Creighton Health. September 23rd should be circled on your calendar. That is the day that all organizations must be in compliance with the HIPAA Mega Rule. The Mega Rule represents the most comprehensive change to HIPAA since it was instituted more than 15 years ago and features many new provisions, including the change of when a patient must be notified of a data breach, expansion of the definition of a business associate, and clarification of who may receive information following the death of a patient. Had a lot of practices ask me about the changes that are coming up next week, so I thought I would go ahead and give a WebEx on this and go over some of the information that you're required to have and get ready. Your practice might want to address certain significant provisions of the Omnibus Rule in your updated policies and procedures. I'm going to list out some of these here. These include a breach notification policy. You want to amend your policy to reflect the presumption that an impermissible acquisition, access, use, or disclosure of unsecured PHI is a reportable breach, unless a risk assessment that addresses at least 4 mandatory factors finds a low probability that the information has been compromised. Now within marketing, this requires the authorization for marketing to reflect that communications encourage the use of a product or service. This does include treatment alternatives or health-related product or service offered by the covered entity. It now may be marketing if financial remuneration is received from a third party. Now, when the proposal rules came out, a good guiding principle on the sale of protected health information is don't be a criminal. However, there is little more than that to that. The new regulatory structure means that covered entities and business associates will need to have greater vigilance in ensuring that previously acceptable remuneration is permissible. You need to review their forms, policies, and processes involving any kind of payment for disclosure of protected health information. It prohibits the sale of protected health information where protected health information is exchanged for financial or non-financial remuneration, unless an exception applies. The final rule defines a sale of PHI to include direct or indirect remuneration in exchange for the disclosure and clarifies remuneration may be financial or non-financial benefit. The final rule includes a catch-all exception for any permissible disclosure if remuneration is limited to the cost of the preparation and transmittal. The final rule explicitly clarifies that while limited data sets are subject to the rule, unlike completely de-identified data, those data sets may be disclosed in exchange for a reasonable cost-based fee. The affirmative requirement for the authorization of sale of PHI is now a third circumstance in which HIPAA specifically requires authorization in addition to psychotherapy notes, which are a mental health professional's notes about a patient that are maintained separately from the record and making marketing disclosures. The bottom line is that a covered entity or business associate may not now receive remuneration for a disclosure of PHI unless an exception is met or the patient signs an authorization containing a specific statement acknowledging that the disclosure will result in remuneration. HIPAA didn't take away the ability for a hospital or healthcare organization or its institutionally related foundation to contact patients for fundraising purposes. However, It did make substantial changes in the type of patient information that can be used or disclosed without patient authorization, and it provides for greater patient awareness and control of their information. So here's some facts from fundraising under HIPAA. Expanding the types of PHI that may be used for fundraising while requiring conspicuous opt-out language of all fundraising communication. The 6 categories of patient health information may be disclosed or used for fundraising purposes without a patient's written authorization. Patient demographic data, health insurance status, dates of the patient health care services, general Department of Service information, treating physician information, or outcome information. Now, speaking of patient authorization, a patient's written authorization is required before a fundraising entity can use protected medically health-related information to filter, target, use, or disclose as a part of fundraising efforts. Protected health information that requires patient authorization prior to use of fundraising includes, but it's not limited to, the diagnosis, the nature of services, and the treatment. The current privacy rule grants individuals the right to request restrictions on the use or disclosure of their protected health information, but covered entities are not required to agree to such restrictions. The HITECH Act strengthens the right to request restrictions on disclosures by requiring covered entities to accept a restriction on disclosing protected health information to a health plan, where the disclosure is for payment or healthcare operations purposes and the protected health information pertains solely to a healthcare item or service for which the healthcare provider isn't involved and paid out of pocket. Now, the Omnibus rule amends the privacy rule to account for this provision. Under this new requirement, if a patient pays her physician in full for a specific blood test and requests the physician not disclose protected health information that pertains solely to that blood test to the health plan, the physician must agree to this restriction unless a disclosure is otherwise required by law. In these circumstances, the healthcare provider also may not disclose the relevant protected health information to a business associate of the health plan. The restriction applies only when the service or item has been paid in full out of pocket. It does not apply to follow-up visits if they are not paid in full or out of pocket. The statement of basis of purpose discussed more specific applications of the rule, and it examines the various issues, including the following. Now, within record keeping, healthcare providers are not required to keep separate records to implement requested restrictions on disclosures, but covered entities will need to employ some method to flag or make a notation within the record respect to the protected health information has been restricted in order to comply with the new requirement. In bundled services, a potential complication arises where multiple services are billed as a single item, but the patient requests a restriction on and pays for only a specific procedure or service. The Department of Health and Human Services is advised, where possible, healthcare providers should unbundle services and apply the requested restriction to the appropriate item or service. They also suggest if unbundling is not feasible, the healthcare provider should counsel patients accordingly and provide the opportunity to pay for the entire bundle of services. Now, within HMOs, some state laws prohibit providers participating in HMOs from accepting payment from an individual above the individual's cost-sharing amount. In these cases, providers should determine whether or not they're permitted to treat the service as out-of-network, in which case payment in full would be legal. If the provider is permitted to accept payment in full consistent with applicable laws, it should be willing to do so and abide by any restriction accordingly. Now, downstream providers, I have that listed there because the Department of Health and Human Services declined to adopt a proposal that would have required healthcare providers to notify downstream providers. These examples are specialists and pharmacies of a requested restriction to a health plan. If the Department of Health and Human Services had adopted such a provision, physicians would have been required to notify a pharmacy or specialist of any applicable restrictions on disclosing information to the individual's health plan. The Department of Health and Human Services declined to adopt such a requirement because it considered it unworkable at this point, given the lack of automated technologies to support such a requirement. In the absence of such a requirement, they have encouraged providers to inform patients that it will be the patient's responsibility to inform those downstream providers. Dishonored payments. Now, if an individual pays for services, but the payment is subsequently dishonored, the Department of Health and Human Services suggests that the provider should make a reasonable effort to obtain payment before billing the health plan. Now, within electronic protected health information, the Omnibus rule also revises this section of the privacy rule pertaining to an individual's right to access his or her protected health information that is maintained in a designated record set. The HITECH Act establishes that individuals have the right to obtain a copy of their protected health information in an electronic format where it is maintained in an electronic health record. In the Statement of Basis and Purpose, the Department of Health and Human Services expressed concern that applying these requirements only to electronic health records and not accounting for other protected health information stored electronically could lead to confusion. Consequently, under the final Omnibus rule, individuals have the right to obtain an electronic copy of their protected health information if the protected health information is maintained in one or more designated record sets electronically. So I've listed out 4 different things here. Under file format, the current provision outlining an individual's right to access his or her protected health information states that PHI must be provided in the form or format requested by the individual if it is readily available. If the requested format is not readily available, the covered entity must provide a hard copy or make some other agreement with an individual. The Omnibus rule establishes that if electronic protected health information is not readily producible in the requested format, the covered entity must provide a copy of the PHI in another readable electronic form, like a PDF rather than a hard copy. As pertaining to third parties, under the HITECH Act, individuals have the right to instruct covered entities to transmit a copy of their PHI that is maintained in the EHR directly to designated individuals as long as the choice is clear, conspicuous, and specific. The final rule requires covered entities to transmit a copy of protected health information to another person if requested by the individual, regardless of whether the PHI is maintained in an EHR. Such requests must be in writing, signed by the individual, and clearly identify the designated person where to send a copy of the protected health information. Now, within fees, the HITECH Act prohibits covered entities from charging more than their labor costs in responding to a request for a copy of protected health information that is maintained in an EHR. The final rule adds 2 factors that covered entities may consider in determining a reasonable cost-based fee. First, you might want to consider labor and copying of the PHI requested by the individual, whether in paper or electronic form. It may include technical staff's efforts to compile, extract, scan, and burn electronic PHI onto digital media and distribute that media. However, the Department of Health and Human Services clarified that such labor may not include a retrieval fee or simply locating the data. In addition, a reasonable cost may account for supplies for creating a paper copy or electronic media if the individual requests the electronic copy provided on portable media. Under timing, under the existing privacy rule, covered entities must respond to an individual's request for protected health information within 30 days of the individual's request, unless the protected health information is accessible only at an off-site location, in which the covered entity has 60 days to respond to the request. In addition, the rule provides for a one-time 30-day extension in extenuating circumstances. The Omnibus rule revises the timing requirements to remove the provision that gives covered entities 60 days to respond where the requested protected health information is off-site facility. Consequently, covered entities must respond to all requests within 30 days, regardless of where the protected health information is stored, unless they are granted a one-time 30-day extension. I would encourage you to make sure that you document in the patient's chart, whether electronically or in their paper chart, when the information was requested, so that you don't get caught up on this fact. This might become a problem for you if you don't have it clearly documented when it was requested. Keep some sort of log. Under the Omnibus rule, the definition of protected health information now expressly excludes the health information of a person who's been deceased for more than 50 years. In addition, the Omnibus rule provides that providers may disclose the protected health information of a deceased person to such person's family members, relatives, or other individuals indicated by the deceased who were involved in either deceased care or payment of care. Providers may disclose only protected health information that is relevant to the family member, relative, or friend's involvement in the deceased care. Protected health information cannot be disclosed if the deceased person expressed a prior preference for it not to be disclosed. This is very, very important. Under the final rule for immunization records, a covered entity may disclose proof of immunizations to schools in states that have laws that require the school to have such information prior to admitting a student. While written authorization for the disclosure is not required, your practice is encouraged to obtain a written or oral agreement from a parent, guardian, or other person acting in loco parentis for the individual or from the individual themselves, if the individual is an adult or an emancipated minor. Now, with your notification of privacy practices, the Omnibus rule modifies and expands the content of the Notice of Privacy Practices to update your NPP to reflect these new requirements and any changes to your privacy practices. Start distributing the revised notice to new patients starting on the compliance date, and will need to update the notices posted at facilities and on their websites, and post the notices on their websites. I'm now going to talk about business associate agreements. To comply with the Omnibus rule, covered entities also will need to likely revise your business associate agreement form to reflect the new requirements. Additionally, the definition of business associate has changed. Some vendors and service providers that previously were not considered to be business associates may become business associates under the Omnibus rule. Your practice might want to consider developing an overall business associate contract implementation strategy, which would also include verifying the business associate status of current vendors, conducting an inventory of all existing BAAs, and planning the approach for renegotiating business associate contracts. Covered entities should also take this opportunity to consider whether the terms for the covered entities BAA form adequately addresses the new Omnibus rule requirements and provides the appropriate protections and safeguards. The Omnibus rule grandfathers most business associate agreements that were in effect prior to January 25, 2013. It does provide you an additional year until September 22, 2014 to amend your current business associate agreements. Beginning on the effective date of the Omnibus rule, the Department of Health and Human Services will begin HIPAA enforcement for the business associates. Business associates must comply with the security rule and applicable sections of the privacy rule. Additionally, business associates have a direct regulatory liability for compliance with much of their business associate agreements rather than having only a contractual liability. Other enhanced requirements, as indicated, the Omnibus rule made a number of modifications and clarifications of the definition of business associate that are significant in determining who qualifies as a business associate. So the Omnibus rule expands the definition to include subcontractors. Business associates need to have their business associate agreements in place with their subcontractors. These business associate agreements not only must meet the minimum requirements of HIPAA, but also need to pass on the restrictions relating to protected health information that the business associate has agreed to in their business associate agreement with the covered entity or the upstream business associate. So I put together a graph here. Basically, I'm trying to make sense of the whole thing with the business associate agreements and the changes here. So as you can see here, I made it kind of simple. There's some basic questions that you can ask yourself. Does the business, vendor, person perform a function in your service on or behalf of your organization? Yes, they are considered a business associate. So you can actually go through some of these right here. In these two instances, does a business, vendor, person act as a member of your workforce performing in their service function under your direct control? If the answer is yes, then no, they're not a business associate. And down here, if the business, vendor, person exposed to protected health information but does not need it to perform their work, if the answer is yes, then they're not. In these other instances right here, the answer is yes. So you can go back to this slide. Again, I will have this available for you so you can actually look at this one particular slide if you have any confusion on what they're clarifying as a business associate. Now, if they are business associates, they really need to consider maybe performing a risk analysis and risk management evaluation, developing security policies and procedures consistent with the security rule, updating breach notification policies, establishing processes for verifying the business associate compliance within their business associate agreement obligations, and developing an approach for negotiating business associate agreements for both covered entities and subcontractors, including updating their templates. Another thing that's within the Omnibus rule, and any time your organization updates its privacy policies, workforce members should receive training on any new and revised policies. In particular, management and higher-level employees should be trained fully on the new breach standards. Training is an important component of compliance within HIPAA and the HITECH Act. Security training should be documented and maintained in your event training logs. You can also track these within our contract tracker within the MSO website. If you would like assistance with this on how to do this, please contact me, send me an email. I'll be happy to come out to your practice and show you. And program details may be requested during an audit or investigation, so it's important that you keep up with it. So I thought in part of this, maybe I would give some basic things of tips on how to avoid violating HIPAA. All healthcare providers have a responsibility to keep their staff trained and informed regarding HIPAA compliance. Whether it's intentional or accidental, unauthorized disclosure of protected health information is considered a violation of HIPAA. So I'm going to go through 5 tips to avoid violating HIPAA. First thing, routine conversation. Healthcare professionals should be very, very careful to refrain from disclosing information through routine conversation. This can easily be done by mentioning to a third party something seemingly insignificant, like saying John Smith had an office visit today. You ever hear that? Then in routine conversation, you violated HIPAA. Discussing patient information in waiting areas, hallways, or elevators should strictly be off limits. Sensitive information can be overheard by visitors or other patients. Also be sure to keep patient records out of areas that are accessible to the public. Trash. Now, protected health information should never be disposed of in the trash can. Any document thrown in the trash is open to public and therefore a breach of information. Placing protected health information in trash bins or dumpsters are not a secure method of disposing of PHI. Companies have been fined or illegally discarding protected health information in dumpsters, complete with patient names, birth dates, social security numbers, and other protected health information. So what are some tips that you can help your employees comply? Before protected health information can be thrown out, it should be made indecipherable by shredding or burning. The surest way is to hire a reputable company to destroy the records. Help your employees comply by placing small bins at each workstation clearly labeled PHI for proper disposal only, do not trash. This will prevent information from accidentally ending up in the trash. making it a policy that all paper documents be placed in the recycling bin, whether there's PHI on it or not, to avoid any confusion, and make random inspections to make sure that everybody is compliant. We do partner with a company called Paper Tiger in case you are looking for somebody to help you with disposing of protected health information safely. If you want more information on this, please contact me. Their information is also located on our MSO website under Service Partners. Another tip to avoid violating HIPAA, gossip. Now, gossip is particularly hard to control in the business office or in the office setting in general when you deal with patients. That's why it's important to access information be strictly limited to employees whose jobs that require that information. This type of violation can be particularly damaging to the reputation of your practice, especially in small communities where everybody knows everybody. Marketing. Selling patient lists or disclosing protected health information to third parties for marketing purposes is strictly prohibited without prior authorization from the patient. Remember that disclosure of patient information should only be accessed for the purpose of providing quality care. If you want more information on this, there's actually the model forms are located on the website right here. And then also the model forms for the business associate contracts and agreements. They are slightly dated, the ones that are out there now from January 25th, but they're also located here. So again, you can reference this information. This WebEx is specifically just on the HIPAA Omnibus rule and changes. I've had a lot of practices, again, asking me for what changes that are coming. Hopefully this information was helpful. And the websites that are listed here, again, they will give you more information. I try to make it a little bit more simple for you to understand, but there are some more information in forms that I will also include on our MSO website in case you're needing them. In order to access the forms or to get access to the PDF of this website or other ones in the past, you just log on to our website, go on to the Resource Center, and under the Office Manager Forms Toolkit, I'm also going to have compliance plan there in case you aren't up to date with your compliance plan. There is a sample one within there, and then I'm also including the new Business Associate Agreement samples within there. And then they have the programs toolkits. And in training, I don't know if you're aware of this or not, on our MSO website, it does have HIPAA training and OSHA training. We are updating this HIPAA training and OSHA training for October, just to let you know. So the minute that happens, I'll send out a notification. But when you go in there, you basically go into the training center, has all the tests and everything in there. If you're wanting this, you just have to click on Submit a Request, and you can have this placed within your website. Now, once everybody is up to date and they're on their completed their HIPAA and OSHA training and you've received your certificates, then I can show you how to put them in the contract tracker for secure storage. I'm now opening this up to questions. I appreciate your participation today, and I hope you all have a wonderful day.